Preserving Wealth Down the Generations. Welcome to our short presentation on preserving wealth down the generations. Here is some brief background on us. We have been organising educational seminars for decades. We are completely independent and unbiased. The seminars are sponsored and presented by a range of fully qualified solicitor practices, estate planners and financial advisors with many years' experience. Lasting 2 hours, the seminars are held in a relaxed atmosphere, without any selling, and with the freedom to ask questions. Topics covered include strategies for keeping wealth in the family, care fees and long-term care, gifting money to children and grandchildren, how to reduce inheritance tax, will writing and setting up lasting powers of attorney. Please note the following points. This short presentation is not a replacement for the seminar. The presentation contains generic information and should not be taken as advice. It provides an overview of areas that can impact on your ability to pass wealth down to the next generation. Okay, let's make a start by taking a look at will writing. You may be surprised to learn that most people haven't made a will. But why? Firstly, it's a morbid subject. Most of us prefer not to think about it. Secondly, some people suffer from ostrich syndrome, with their head in the sand. So what happens if you don't make a will? When a person dies without leaving a valid will, their estate must be shared out according to the rules of intestacy. Only married or civil partners and some other close relatives can inherit under the rules of intestacy. Another common question is, should I write my own will? Please be aware of the pitfalls of writing your own will. Many self-written wills contain errors and mistakes, are out of date, and are not actually legally valid. Ask yourself, is it worth risking to save a few £100s on a professionally drafted will? If someone makes a will, but it's not legally valid, the rules of intestacy decide how the estate will be shared out, not the wishes expressed in the will. Remember, you should always seek professional advice. Another common misconception is that if you have made a will, you don't need to do anything else. As with many things in life, it's not quite that simple. It's important to recognize that a will can only protect your assets at the time of death, and not during your lifetime. There are, unfortunately, a number of threats to your estate during your lifetime, which can result in there being little left to actually pass on in your will. So here are the areas that a well-prepared estate plan should consider for you and your family. Death and remarriage. Divorce and remarriage, particularly for your children. Sideways disinheritance. More on that shortly. Bankruptcy, again particularly for your children. Care costs, with more and more people now going into care. Inheritance tax, payable above a certain threshold on your estate. Funeral wishes, to relieve the stress on your loved ones at a time of grief. Okay, let's look at some examples. Here we have Peter and Sandra with 2 grown-up children. Kevin is the first child and Julie the second child. Kevin and Julie leave home and get married. Neither Peter nor Sandra go into care, and so their assets are eventually passed to their 2 children in accordance with their will. A large proportion of marriages end in divorce, and sadly Kevin's is one of them. Kevin's ex-wife is paid half of his inheritance in the divorce settlement. How do you feel about your son or daughter's ex-spouse inheriting your assets? We see this happen all the time. In another example, Sandra passes away, leaving the house and assets to her widow Peter as set out in her will. Peter gets lonely and decides that he needs someone else in his life. Peter remarries, and sometime later he passes away, leaving everything to his new wife, who then leaves everything to her own children. As a consequence, Peter and Sandra's own children receive no inheritance whatsoever. This situation is known as sideways disinheritance, and it affects many families every year. Inheritance tax, or IHT for short, is known as a voluntary tax. Former Chancellor Roy Jenkins famously described inheritance tax as a voluntary levy paid by those who distrust their heirs more than they dislike the inland revenue. IHT is a one-off tax which is payable on your assets and possessions above a certain threshold. IHT can remove a substantial chunk of the assets that you are planning to pass on. Each year, billions of pounds are paid in IHT, and the number of estates paying IHT is increasing. In another scenario, Peter and Sandra pass away and leave their assets to the children Kevin and Julie as set out in their wills. Julie's business later fails, and she is sadly declared bankrupt. Julie's inheritance is then used to pay the creditors. This was obviously not the way that Peter and Sandra had intended their hard-earned assets to be used. As our population ages, an increasing proportion of people are now going into care. Care costs vary across the country, but just a few years' stay in a care home can easily run into hundreds of thousands of pounds. In many cases, the cost of care is funded by the sale of your home. Going back to the example of Peter and Sandra, who were married with 2 grown-up children. When Peter passed away, his assets were inherited by Sandra as his next of kin, in line with his will. Some years later, Sandra went into care, and the equity in her home and other assets was used to fund the care costs. As a consequence, Peter and Sandra's children received little inheritance. Okay, let's take a look at loss of capacity. A person lacks capacity if he or she is unable to make a communication or decision about a particular matter because of an impairment of the brain. This may be the result of a variety of conditions, including dementia, mental illness, a learning disability, brain damage, intoxication. 1 in 3 over 65s develop dementia. Yet don't assume relatives can just walk into a bank and access your money, even to pay for your care. Unless you have a power of attorney already, loved ones need to apply for one through the Court of Protection, which can take months and can be costly. So if you don't have lasting powers of attorney, make sure you put them in place and don't leave it to chance. Funeral costs are the first payment from your estate. By putting funeral arrangements in place, you can protect against cost increases and save your family a great deal of anguish at a time when they least need it. So, in summary, making a will is not enough to protect your family's estate. In particular, a will does not protect against the following: divorce, not necessarily you, but your children; widowed spouses remarrying; business failure, again, particularly your children; inheritance tax; care costs; loss of capacity, such as dementia; and funeral costs. The good news is that you can protect against these threats by proper planning. So let's have a quick look at these. The solutions needed are as follows. Professionally drafted wills. And remember, please don't try to write your own. Trust planning, to protect your family's assets for up to 125 years. Tax planning, and ways to legitimately and legally lower your IHT bill. Lasting powers of attorney, both a health and welfare power of attorney and a property and affairs power of attorney. Long-term care and funeral planning. Warren Buffett said, "Someone is sitting in the shade today because someone planted a tree a long time ago." Estate planning is an important and everlasting gift you can give to your family, and setting up a smooth inheritance isn't as hard as you might think. Please visit our website for details of seminars in your area. Or to request access to advice, please call 0845 299 3834 or email contact@inheritance-preservation.co.uk.